What does compromise get you? Absolutely nothing. That's exactly what we learned 2 years ago when Republican Senator John Cornyn helped pass the largest gun control bill in 30 years. This law led directly to the ATF's latest rule, universal background checks. Hi, I'm Ben, and you're watching the Minuteman Moment. Before we get into the video, please like, subscribe, and leave a comment to help us fight YouTube's algorithm. In just a few short weeks, ATF's latest rule, definition of engage in the business as a dealer in firearms, will take effect. This rule mandates that all firearms transactions must be done by licensed dealers. Say goodbye to private sales and the government staying out of your business. Now all transactions will be logs on paper and will eventually make their way to the ATF to add to their illegal registry of gun owners. But how did we get here? Well, we have Republican Senator John Cornyn to thank for that. In 2022, he and Chris Murphy of Connecticut passed the largest gun control bill in 30 years, the Bipartisan Safer Communities Act. Among other things, the law changed the definition of firearms dealer by removing the word livelihood. Because of this one-word change, the Biden administration released a 108-page proposed rule mandating universal background checks. GOA and our members fought this rule valiantly. We submitted over 85,000 comments to the Federal Register. ATF sure was unhappy about having to read each and every one of those. And while the comments didn't stop the rule from becoming final, it did in fact change the scope of the rule itself. In fact, ATF had to respond to GOA's comments 39 times in the final rule. Now we'll do a separate video about each of those responses we got from the ATF and how it affected the final rule itself. ATF having to change their rule doesn't change our plans whatsoever. We just filed our lawsuit against the ATF because this rule is awful for gun owners. In fact, because of this rule, we're one step closer to a gun registry, with ATF amassing a database of 4473 forms. This rule ensures that all transactions are eventually captured by the agency. So what does this mean for you? Well, we had our lawyers look at the rule, and here's the 5 worst parts. First off, even one firearm sale counts as being engaged in the business, even if family members. Does ATF really think that law-abiding citizens want to read the Federal Register and keep up to date with their nebulous soup of ever-changing gun regulations? Of course not. Those who sell firearms to their family members may wind up in prison because of this rule. Second, you don't even need to sell a gun to be considered engaged in the business. How might you ask? Well, ATF says that even a single firearms transaction or offer to engage in a transaction, when combined with other evidence, may be sufficient to require a license. This means your conversations with friends about selling your personal collection could be misconstrued by the ATF to mean that you meet the definition of willing and able. Imagine you're a historical firearms collector. A friend sees a crate of Mosin Nagant rifles you just purchased for display, and you offer to sell it to him. He buys it and tells you he'd think it'd look really cool on display next to a crate of SKS rifles too. You tell him you'll keep an eye out for any good deals. Now ATF will presume you are engaged in the business of selling and buying firearms. Switching to the modern end of this argument, say you bulk bought polymer 80s and other 80% kits when they were on sale before they were banned. Your girlfriend wants to buy a gun for home defense, so she buys a full-size kit off of you. Say she accidentally drills one of the holes wrong, so you give her another kit and she takes you out for a nice steak dinner. Later, you offer her a subcompact kit so she can build for concealed carry and suggest you could build it together next weekend. Now ATF will presume that you are engaged in the business of reselling firearms. Third, presumptions are still instructive in criminal court and there's reasonable permissive inference. In layman terms, this means that the ATF can use their made-up standards as proof that you were engaged in the business. This reverses the normal judicial process of innocent until proven guilty, and instead has it so that you are assumed to be guilty of being engaged in the business if you've done any of these things, and have to prove you weren't actually engaged in the business instead. For example, your text messages with a friend offering to sell them one of your rifles that you got a sweet deal on, but realize you'd rather have cash to spend on something else. ATF can use these to draw what's called a reasonable permissive inference in court, basically saying, yeah, even though you had never actually sold the gun and were just talking about it, we're gonna tell the jury that your text messages basically mean that you're dealing without a license and let them decide. Fourth, continuing with the presumption theme, the rule reads that selling a firearm within 30 days of its purchase, or a year if the firearm is new or like new in its original packaging, or of the same variant, make, or model, is considered as being engaged in the business as a dealer. Let me lay out a few examples of how this could unfairly get innocent people caught up in the rule. Okay, for the first situation, say you see a great deal on a 2-for-1 deal on cheap AR-15 lowers. But you don't actually want to build 2 AR-15s. You want to build a high-quality AR-10. So you offer to resell the 2 lowers to a friend. ATF will presume that you've committed a federal crime. Second situation, you buy Glocks with sequential serial numbers for your wedding party. But your fiance cheated and you break off the engagement. If you try to sell the Glocks to help you forget the pain and move on from the past relationship, ATF will presume that you've committed a federal crime. For the third situation, say you buy a 3-gun competition loadout from a friend. A rifle, a shotgun, and a pistol. But an emergency comes up where you need the cash to pay for your kid's cancer treatment in 2 weeks. If you sell those guns to prevent your child from dying of terminal cancer, ATF will presume you have committed a federal crime. Now you can see how ridiculous this rule is and how it could trap these people who never intended to be a dealer, but instead either fell in hard times or simply trying to move on with their lives. And finally, number 5. If you've maintained any record to track the profits or losses from firearms you've sold, it's also considered being engaged in the business. Again, more innocent people who keep records for taxes or insurance, or even just want to list out their inventory for their will, would get caught up by this. All of these are perfectly reasonable situations for why an average person would maintain documents with the number of firearms and their values without intending to be a firearms dealer. Okay, so there's not just 5 things wrong with their rule. The entire rule is rotten to its core. It's aimed at trying to register the transfer of every gun and gun owner. And no amount of compromising or cutouts will redeem it. That's why we're filing our lawsuit against the ATF to overturn it. And we're not just fighting in the courts. We're working with our allies in Congress to pass a Congressional Review Act on the Engage in the Business rule. This fight is being spearheaded by Andrew Clyde in the House, and ironically, John Cornyn in the Senate. Seems like Cornyn might be having some compromise remorse after all. So please, call your representatives and let them know that you support a Congressional Review Act on the new ATF rule. Now thanks for watching. Be sure to like, comment, and subscribe to stay up to date with all of GOA's latest fights for your rights.